An incident from nearly a year ago is prompting a snowflake to continue a temper tantrum long after a judge has dismissed the majority of his case. A man by the name of Daniel Black filed a federal civil rights lawsuit against former Milwaukee County Sheriff David A. Clarke, Jr. Clarke, along with several unnamed deputies in Milwaukee County were all named as defendants in the suit stemming from a brief run-in on an airplane. 24-year-old Black claimed in his lawsuit that he was the victim of an unlawful stop and arrest at Mitchell International Airport on January 15, 2017. He claims he was detained, interviewed and escorted out of the airport by a half-dozen deputies after Amir had nodded Clarke on a plane. The lawsuit asked for unspecified damages as a result of alleged violations of Black's constitutional rights to equal protection and freedom from unreasonable searches and for emotional distress and other compensatory damages. Black and Clarke were on the same Dallas to Milwaukee flight on January 15, 2017, when Black saw Clarke on the plane decked out in Dallas Cowboys gear. Black then asked him if he was David Clarke. Clarke confirmed he was the same, and Black shook his head at Clarke. The suit says, and then Clarke asked Black if he had a problem. Black says in the suit that he responded by saying he did not and turned and walked to his seat in the coach section of the airplane. The flight itself was uneventful, however, upon landing in Milwaukee, the fireworks began. When the plane landed in Milwaukee, Black was greeted by 6 sheriff's deputies, identified in the lawsuit as John Doe. Clarke directed the deputies to take Black aside and question him, surmising that his questioning of Clarke's identity and subsequent disapproval may signify Black meant potential harm. The deputies then escorted Black from the airport. Black then put Clarke on blast on social media, posting about the incident. Clarke responded on social media calling Black a snowflake for his reaction to the incident. Black filed a lawsuit shortly thereafter claiming violations of his Fourth Amendment right against unreasonable seizure, retaliation for exercising his First Amendment rights by having him stopped at the airport and the subsequent mockery on Facebook, and his due process rights under the 14th Amendment. The suit also sought to have the county held liable for Clarke's actions. Black claimed via his lawsuit that Sheriff Clarke singled Black out for his political opinions, despite Black's own testimony that he actually walked up to Clarke and asked his identity. Black identifies as a liberal and supported Senator Bernie Sanders, IVT, in his bid for the presidency in 2016, while Clarke himself was and is an avid supporter of President Donald Trump. The suit describes Clarke's actions as irrational and unrelated to any legitimate government purpose. Last year U.S. District Judge J.P. Stadtmuller, a Reagan appointee, dismissed the majority of the charges. He granted a summary judgment to Clarke on the Fourth and one of the First Amendment claims. He dismissed the 14th Amendment claim as completely without merit, as well as dismissing the claims against the county and the 6 sheriff's deputies originally identified as John Doe. Stadtmuller stated in his 27-page ruling on Friday that while Clarke's actions reflect poor judgment, they do not shock the conscience, therefore did not support any level of due process claim. The judge also determined that Black's some 15-minute conversation with deputies could not be labeled a seizure, as the sheriffs never drew their firearms, used friendly language and were not expecting nor did they arrest or cite Black for anything whatsoever. However, Judge Stadtmuller has allowed the claim that Clarke retaliated against Black on social media, therefore, prohibiting Black's free exercise of his First Amendment rights to shake his head at Clarke to survive. The trial for this allegation is currently set to start on January 22, 2018. The judge will allow a jury to decide if Clarke's reaction to Black's post on Facebook about the incident in the Milwaukee airport was intended to be any level of threat or intimidation that amounted to retaliation against Black. The lawsuit alleges that by taunting Black via a social media platform, Clarke misrepresented what happened on the Dallas flight, and his comments on social media were intended to incite violent verbal assaults against Black, which has happened. It seems as a result of this lawsuit, the FBI used it as the impetus to pursue an investigation into Sheriff Clarke. On March 7, FBI Special Agent Jennifer Wachowski applied to search Clarke's Gmail account, saying there was evidence of a crime. A judge approved the warrant, and the FBI carried out the search the next day. On May 3, the U.S. Attorney's Office decided not to pursue criminal charges against Clarke, saying it would be difficult to prove the then-sheriff had broken federal civil rights laws. Local Milwaukee news affiliate Fox 6 now reports how Clarke initially wanted to respond to the incident concerning Black as revealed in the FBI's search warrant application on January 17. The sheriff ordered a subordinate to write a Facebook post about Black that read, "Sheriff has taken this complaint under advisement and summarily determined that he can go to hell." The subordinate responded that the sentence could not be posted to Facebook. According to the FBI document, Clarke responded, "Can't. Is there a computer problem?" The post that was ultimately published on the Milwaukee County Sheriff's Office Facebook page did include this comment from Clarke: "Next time he, Black, or anyone else pulls this stunt on a plane they may get knocked out." It seems Black's mouth may have written checks his behind was unwilling or unable to cash, and now he is attempting to use the former Sheriff Clarke to garner notoriety as well as financial gain. Hopefully, all will be revealed in the trial beginning on January 22 and justice will be served. Follow us on Facebook at Freedom Daily.